Hi, this is Joe Adams. I'm an American immigration lawyer based in California. On this video series, we'll be discussing hot topics in immigration. We'll be covering your questions and trying to give some answers. We'll be meeting clients who are discussing their own immigration journeys, and we'll be covering breaking news, so stick around. If you've ever thought about applying for an O-1 category visa or an EB-1 category green card, you should definitely be thinking about who will sign off on letters of recommendation. Letters of recommendation are used strategically by a skillful practitioner to either add to the evidence or augment the evidence that's facing the immigration officer deciding your case. For an O-1 visa, one of the criteria specifically asks for evidence that the person has been held in high regard by recognized experts in the field. So letters of recommendation are a commonplace way to satisfy that criteria. For an EB-1, the criteria are a little bit different and don't quite hit that mark, but we still use letters of recommendation in a very similar way to add to and augment the evidence to persuade the officer that the case should be approved. A letter of recommendation can add a lot of depth and vibrancy to a case that's otherwise dry and in paper form only. Remember, O-1 processes and EB-1 processes are what we refer to as petition-based applications, meaning we're submitting a detailed written petition to a government processing center here in the United States, and we presume that the officer has no specialized knowledge in a person's field. So we have to educate them. And unlike, say, a court hearing or a trial in front of a judge and a jury, we don't bring in live testimony. We don't have the ability to do that. So a letter of recommendation can add a lot of color and detail to a case that otherwise might be dry to the officer. A letter of recommendation, however, is not a character reference, so that the subject turns up on time to work, is pleasant to work with, has great ideas. That by itself is not going to be enough. That they have a good attitude isn't going to be enough. What we want to show on the one hand is that the author of the letter can speak with authority about the subject matter, so that perhaps they've been in a position to hire the subject matter, that they've been in a position to supervise the work, or are themselves a high-profile person in the field. So we want to show, for instance, that the person has awards of their own, that they've been covered favorably in the press, that they've led organizations themselves. Then we want to show that the person who's writing a letter of recommendation can speak with authority about the person who's the subject matter, so that they are familiar with their work, that they've worked alongside the person or have at least reviewed the work. Finally, we want to make sure that the Immigration Service has the ability to verify this information. So always include contact information for the person who's signing off on the letter of recommendation so that the immigration officer can check if they want to. The leading court case in the issue of letters of recommendation that I know of is Matter of Skirball Cultural Center, which was decided in 2012. The case is printed here, and I've got a link to the citation in the description below, and I'll read some of the important highlights. I think it's an interesting case. The Skirball Cultural Center, the petitioner in this case, is a nonprofit arts organization based here in Los Angeles. And what they had sought to do was to bring over a musical group from Argentina who performs music in the klezmer style. So it's traditional Eastern European music in the style of Central and Latin America, using their traditional instruments. The Skirball Cultural Center had filed the case. The sole issue to be decided on the appeal was whether or not the beneficiaries group is, quote, culturally unique. There's a code section that provides for culturally unique groups. In support of their case, the Skirball Cultural Center had provided a letter from Professor Joseph Kuhn of the University of Southern California, who teaches, researches, and publishes on Jewish music and the music of Latin America. And he went through line by line, detail by detail, showing that the orchestra was culturally unique. The Immigration Service denied, and then on appeal, and I'll skip towards the good part, in the present matter, the director, meaning the USCIS director, did not question the credentials of the expert, the university professor, take issue with their knowledge of the group's musical skills, or otherwise find reason to doubt the veracity of the testimony. So They didn't say we don't think he's telling the truth or we don't think he has the right background. The AAO, the Court of Appeal, finds the uncontroverted testimony to be reliable, relevant, and probative as to the specific issues of fact. Accordingly, the expert testimony satisfies the evidentiary requirement under the code. So I see this as a broad endorsement of expert opinion testimony, just like if we were in a regular state or federal court where we would bring in, say, an expert, say a professor, say a coworker, say a boss, someone who could speak with authority as an expert in the field. I hope you enjoy this little overview of how letters of recommendation work for O-1 and EB-1 cases. If you have any questions, just let me know and stay tuned for future episodes.